So we'll look at the notes on our third branch of government, which is the judicial branch. The judicial branch is described in Article 3 of the Constitution. So far, we talk about the executive, legislative, and judicial branch. So when we talk about the judicial branch, we're talking about the courts. We're talking about our courts. These are where trials are held. There are two types of trials. We have criminal trials and civil trials. We talked about types of law earlier in the year. And so the courts in the judicial branch settle disputes. A criminal trial, you're trying to determine if a law was broken, if a crime was committed. You have the judge kind of acts as the referee. The jury is the one that decides innocent or guilty, not guilty. If you quick review the Bill of Rights, juries are guaranteed by the 6th and 7th Amendment. The right to trial by jury originated with Magna Carta. A little more review. All right. Civil trial would be civil law. There's not a crime committed where there are damages. So in a divorce, who gets what? Car accident, who has to pay for damages? A person is suing usually for money damages, and that's civil law as opposed to criminal law where there's a crime committed and we want to punish that person to try and not have people commit crimes. All right. So another main job of the courts is to interpret the law. And so that is what the third branch of government does. Here's a great summary of separation of powers. Legislative branch, Congress makes the law. Executive branch, president enforces the law. Judicial branch, they interpret laws and whether they are constitutional. They follow our rule book, the Constitution. So under the Articles of Confederation, this was one of the weaknesses. There was no national court system to settle disputes between the states. So we included that in the Constitution to fix that problem. The Supreme Court is established in Article 3. It says the judicial power of the United States shall be vested in a Supreme Court. Now, this is another topic we will cover a little bit later in the year, but we have what's called a dual court system. Dual means two. We have two court systems in this country. We have state courts and we have federal courts. So we're talking about the federal government, so we'll be talking about the federal court system. But Florida also has their own state courts as well. We'll talk about that more later in the year as well. All right, so here's how is the federal court system organized. There's 3 levels. You have district courts. This is where most trials and cases will begin. And then you have appellate courts. The appellate courts will hear appeals cases from the federal courts. And then you have one Supreme Court. So cases will usually start at the bottom and work their way up into the Supreme Court. So there's 94 federal courts, 13 appeals courts, and 1 Supreme Court. That's the highest court in the land. Okay, so talk a little bit about jurisdiction. Jurisdiction means we have 3 levels of court system: district courts, appeals court, Supreme Court. Who gets to hear the court first is original jurisdiction. Who gets to hear the case first? Almost always it'll be the district courts. So this is where the trials will occur. They will hear the case first, and then if someone wants to appeal, it'll go to the Court of Appeals, and if someone wants to appeal that, it could go to the Supreme Court. This will never have original jurisdiction, the Court of Appeals, because they don't hear trials. They only hear appeals cases. So that means the case has to have happened somewhere else first. So most cases will begin down here. This is where most cases have original jurisdiction, means which of these 3 courts gets to hear the case first. It'll be here and would work way up. There are rare cases where the Supreme Court has original jurisdiction, but, there we go. Okay. So district courts, these are the ones on the bottom. There's 94 of them. These are trial courts. I actually did jury duty in a United States district court. It was a drug case. It was a federal case. I was a juror who had to decide guilty or not guilty, right? And so these are what you think of as a normal trial court. There's 12 jurors. There's a judge. You have evidence and testimony, and then they decide guilty or not guilty, right? And so that is the bottom level. That's the district courts. Now, in appeals court, there is no jury. All they're doing is there's 3 judges, and they review a lower court's hearing to see if everything was done correctly. They don't hear new evidence. They don't redo the trial. They just make sure that everything was done correctly. Did the district court do everything correctly? If not, they'll overturn the verdict and send it back to the lower courts. If so, then they uphold the verdict. All right. So again, the Court of Appeals, we're talking about this. There's 13 of them. It's a 3-judge panel that reviews the trial to make sure the law was applied correctly. All right, and then you have the last level. Well, that is the Supreme Court. This is the highest court in the land. There are 9 Supreme Court judges. They serve lifetime appointments, and only a few dozen or maybe 40, 50 cases make it to the Supreme Court every year. They start in the district courts, then they go to the Court of Appeals, and they may go all the way up to the Supreme Court. And if the Supreme Court wants to hear a case, they will issue what's called a writ of certiorari, which is a vocab word you need to know. It's in your notes. It means that they want to hear a lower court's case, and they want to hear the evidence. Again, 9 justices who serve for life. Okay, this is incredibly important. I can't stress this enough. The Supreme Court and the judiciary has what's called judicial review. That is the power to declare laws unconstitutional. The Supreme Court can rule a law that Congress passes or an action that the president does as unconstitutional, and that power is called judicial review. This was not in the Constitution. The Constitution does not say the courts can issue something unconstitutional. This power actually comes from an important Supreme Court case that you absolutely need to know called Marbury versus Madison. And all you really need to know about that is it instituted the practice of judicial review. At the time, Chief Justice John Marshall declared an action of the president as unconstitutional. And that established the practice of judicial review. So judicial review, Marbury versus Madison, they go together. Judicial review is the main power that the judicial branch has over the legislative and executive branch. They can declare their actions unconstitutional. Take it in, know it. I 100% guarantee it'll be on your test and on your EOC. Okay. Okay. So here's an example of judicial review. In Brown versus Board of Education, which is a court case we'll talk about next week, the Supreme Court ruled that segregating black and white students in separate schools was unconstitutional. That's an example of judicial review. And it is the main check that they have on the other 2 branches. Okay, so just real quick, let's go back to the beginning here. Just a real quick review. We're talking about the court system, the judicial branch, the 3rd branch of government. Their main job is to interpret whether laws are constitutional. The federal judiciary has 3 levels. See a good picture. You have the district courts that hear trials. You have the Court of Appeals, which is a 3-judge panel that makes sure everything was done right. And then you have the most important court in the land, which is the Supreme Court. Whatever they say is final. And then you have Marbury versus Madison, which gave the judicial branch the power of judicial review, the power to declare laws unconstitutional. All right, make sure you know all that. And that's it. Bye. Am I still here? Bye.